to open the concluding session, and I really congratulate all of you who survived the whole conference and are here to conclude with us. But I think it's really, it's just an opportunity to say things that connect everything that we talked about, to reflect more and say goodbye. So I think James will
Okay. Good. Okay. So thank you. It's great because everybody, I think, feels there's so many very interesting ideas and intersections. So I just wanted to talk for a few minutes and try and do what you suggested. And I wrote some notes here. It struck me that the original theme, as it was first presented in the email from Rachel and Leora and Doreen and Natalie, was lawmaking from below or bottom up or grassroots. And a conference focused on the contribution of victim groups to international law. And we reached international law and international human rights law from the margins. So contribution suggests a positive thing, right? A progressive endeavor, kind of civilizational paradigm. And it's an apologetic word, right? There's so many books about the contribution of X to this, right? And it's a book that, it's a term which suggests that the thing is a good thing and that the people are, need to be lauded for what they've contributed. From the margins, in the final version of our title, right, International Human Rights Law from the Margins, suggests marginalization, displacement, powerlessness, and a relationship to international law and human rights of opposition or critique or using it from the outside. And the implication seems to be less what the margins gave to human rights law than what it means for them, right? And it's also ambiguous about the margins, and I think that the final panel nicely illustrated this. I'll say something about it. It's ambiguous about what the margins is. Is it the people, or is it the place? And in some cases, that's exactly the challenge. So then, international and human rights law. So I want to talk about these terms for just 2 more minutes, and then say something to ask a couple of questions for us to think about. The first thing that struck me about our new title is that the assumption is that international law is distinct from human rights law, right? There are some people, I think, who would say that there's no distinction. To talk about international law in the modern sense that we want to talk about it as not just being only interstate or, a positivist system that doesn't really recognize groups, individuals, and other things. 1948, in other words, was a moment in which human rights law said sovereignty can be bended to give us a new kind of international law. So some people might say you can't have human rights law without international law. That's an interesting question, because on the other hand, these panels show us that human rights law is only one strand of international law. That seems pretty clear. In fact, many papers discuss that, and many papers also show us that not only is human rights law not identical to international law, but human rights law is a very narrow kind of law. And I was struck by that in many papers. The paper about Crimean human rights activism, which is a whole discussion about human rights activism on behalf of victims and on behalf of people, Ukrainians and Tatars in Soviet-occupied Crimea, without addressing the illegality of the intervention and the annexation, right? And that's okay, but it's a striking separation. This came up, I think, in recent talks and also in Sandy's talk, which is the whole question about indigenous land rights without the larger questions of nationality and annexation. And of course, Ilan's remarks on paper basically pushed that even further and said you cannot disentangle, conquest, territorial conquest from human rights things. But I think that's also striking in the whole slew of fascinating papers we heard about the narrowness of human rights law in terms of its conservative uses, right? This idea of populist constitutionalism seems to suggest that human rights law can be turned and used from outside in ways that can repurpose it. So I could go on and on and on, but the big question for me is basically, I'm still not clear how people around this table think about how human rights law fits into the international legal system. Is it itself on the margin of the international legal system, or is it something inside it and it's one piece? And many people here are practitioners as well as scholars. So it doesn't matter. It's about finding the tool and using it. But that was interesting to me. That takes me to the minute I want to spend on the margins. So I went through the program and I thought, okay, what are our margins? And we have these groups that you nicely curated us into, right? Victims was the first panel, persons and peoples as victims, that kind of marginality. And then the second panel was margins itself, right, which was sort of gender, professional, as well as geospatial. And the third was margins, conservatives, religious and gender-based and political conservatives. And the fourth was this bottom-up, right, nature/animals, NGOs, and minority identities, right, inside Israel-Palestine. And then there was a backlash panel too. And we talked about during the break how the backlash panel doesn't really fit because it's not exactly about international law, even though it's about this comparative thing of populist constitutionalism, what's going on in this country and what's going on abroad. But the fact that it doesn't fit is also one of these great things that exposes the whole of what we're doing here, right? And it doesn't fit in a sense because it seems to be about powerful, empowered majorities, right, doing what they're doing, not the marginal. But then that left me with a question: what is the difference between the people who push for the nation-state law and are the majority, they're the empowered majority, and then these other conservative norms entrepreneurs, both in other countries or in this one, who also use human rights law and human rights rhetoric to push for their visions, right? So in one, we kind of were presented these conservative groups here as marginal to the human rights world, right? But kind of invading and entering and taking it over. But in the other image, we have this kind of norm of no, that's actually the majority that's just using this human rights law, whether it's internationally or whether it's actually constitutional law, to kind of twist it and just push forward its majoritarian aims. So that to me is a really interesting question about the margins and what marginal means. I think somebody mentioned this at the end, but I think Doreen suggested this. If you think about, as I do, sort of the legal history of human rights NGO activism, especially if you view it from a Jewish standpoint, and I don't even mean putting one political spin on it, the general consensus would be that Palestinian NGOs, Palestinian advocacy, is very successful and has a central place of status and authority at the UN. That's the perception. And maybe because of its statelessness, that it maybe you said this, its statelessness, Doreen said this, right? Its statelessness actually gives it a certain cachet and status, as well as a certain necessity to do that. And on the other hand, the work you do in this context makes it patently obvious that if there's anything that's marginal, as you described, it's the experience of doing cause lawyering and doing this here. So all of this points to the last thing I wanted to just throw out, which is really about thinking about this in terms of the historical perspective. And that's the question just of power, right? The assumption still seems to be that international human rights law is a powerful tool, and it is real, and it is a good thing. It's a benevolent thing. Even as we also talk about, and you use this very powerful phrase of laws, Israeli law is the master's tool, right? And there are people now who say that international law actually embeds in it certain inequities too. So that's an interesting thing to think about. And that took me back to this question of the historical perspective and this word minority. So again, margins of thinking about that, to think about Palestinian experience here is to think about both a classic paradigmatic minority and also a majority. That its minoritization is exactly part of the way it is, legally circumscribed and legally dominated by law. And this question of minority majority was something that was very central for the people that I spoke about and we've been talking about throughout the conference of Jewish groups 100 years ago. Jews are the paradigmatic minority, before World War II. And yet they're at that very point in this weird position of being, as I said at a conference a couple weeks ago, both the greatest victim of the League of Nations state system and the greatest beneficiary, because they get a state out of it, right? And that all took me back to thinking about the conference that was held here in 1974 at Tel Aviv Law School, at which Jacob Robinson, then at the end of his life, who traveled that journey from Eastern Europe to here, gave a talk on international protection of minorities, a global view. And he kind of gave two different interpretations of what went wrong with rights before World War II. And I want to present both of them and just leave us to think about that. So he started by saying there was a joke in Geneva in the 1930s that the Jews invented the international protection of minorities and the Germans and Hungarians used it. And he said that's really what happened, right? The Jews actually didn't use the system as well as they could have. And his proof was, he was the first empiricist, out of 585 petitions that were put forward to the League of Nations during this period, only on minority, only 24, he said 24 were put forward by Jewish groups. The rest were by other national groups who had countries, Hungary, Germany, Poland, Lithuania to work with. And only 3 went up, and really only one, this Bernheim petition, 1933, was successful. So basically he said in this speech and elsewhere, the problem was that we just didn't use the tools we had enough. You know, forget about the fact that the League of Nations was a flawed system. It was a system. We could have used it more. And the implication is minority groups, if they're just more assertive. And he said the reason we didn't use it was because we feared it would compromise our legal status in all these other countries in Europe. So that suggests a paradigm that we could think about today. It doesn't matter if human rights law is flawed or has power embedded in it. You use it if it's a tool, right? And if you don't use it, then you're just missing the opportunity. But in the same speech, he contradicted himself, and he said that what went wrong, he said the strength of the Code of Minorities, which was referred to as the whole minority rights system, was indissolubly connected with the Versailles system and its assumptions, which were 3: democracy, economic liberalism, and the rule of law. Each crack in that system had its repercussions in the functioning of the code. So that, I think, really takes us to where we are today and what we talked about, especially with the populist constitutionalism panel, which is, does it matter if the whole order is crumbling, right? If we're talking about neoliberalism, if we talk about these large things, if there isn't democracy, does that legal activism work? Can it make a state that is an illiberal democracy more liberal, or will it not ever do that because we're in this seismic shift moment? So that's the question I come away with, is more activism and more use of the law a good thing, or and I think people have hinted at this, or does it not matter because ultimately the larger questions are political and economic?